Are you going to be just kind of with him?
This is my client representative, Mr. The commission has any questions of him, he won't be speaking.
Okay, sounds great. I just want to make sure if not, we need one of these filled out. Thank you. Go ahead, Mr. Shirk.
Commissioners, good morning. Michael Shirk with the Enforcement Division. This matter comes before you on a proposal for decision issued by an administrative law judge on December 17, 2014. The administrative law judge in the proposal for decision found that I had sustained the burden of proof in establishing the respondent tow company on two separate. Specifically, the tows were conducted in the absence of legally required signage. The administrative law judge at that point assessed for each violation, the error being that the administrative violations were classified as first violations. That's our first point of dispute with this PFD and the first request for change that we are going to make. The second issue, the administrative law judge did not find at my request that the tow ticket had contained information, charges unrelated to the tow itself. I did file exceptions on that matter, but those exceptions are not being brought forward, and there's no request that the proposal for decision reflect for his charges on the tow. Therefore, the only issue is the administrative law judge's calculation of penalty for the two illegal tows, which were, as a matter of fact, established. Administrative judge found that these penalties should be assessed as. Position was that these were being taken against respondent in a 3-year period, and therefore, under the long executive director and of staff, that these were properly classified as third violations subject to the Class F of $4,000 and liability. Judge erred in classifying these as first-time violations rather than third-time violations, and request a modification of the proposal for decision, simply that the penalties should be assessed at $4,000 each for two, which were each third F violations, along with the suspension of respondents. Questions, I'm happy to answer them.
Any questions, Mr. Shirk?
Two.
Yes.
Were the illegal two tows, were they the same night? Days apart were they?
On April 27, 2013, ending in 4311. The other tow was on July 28th in 9724.
Okay, and then also, what were the disciplinary actions?
There was a disciplinary action on November 16th, included towing in the absence of appropriate signage. However, at that time, it was a Class C violation. There was also a violation or an agreed order on September 11th, 2012.
Or
Okay, the first one, which was an agreed order,
they were
two separate agreed orders.
Okay. So on the September 2012, it would be
September 2012, tow ticket was not properly prepared and issued for a non-consent tow. The tow were not directly related to the towing of the vehicle. And the tow ticket provided the third included charges not directly to the tow of a vehicle. So that was the case ending in 1577, the September.
kind of confused. What was the violation for the 2012?
First violation is what the
There were 3 violations in that one incident order, or were they 3 separate incidences that were combined in one?
incidences
Okay.
combined in one agreed order,
Okay,
brought under one notice of lesser violation for incident was May 26, 2011.
oh, okay. Is that separate from the agreed order from November 2011?
Can you start over with we're getting confused with the dates.
Certainly. Agreed order issued by the executive director on September 11th, 2012. That $1,000. The respondent failed to issue a tow ticket for each of the tows performed under the case happening or the violations happening on May 26, 2011. That 553, an incident of May 26. Then in the other violation in the agreed order, because agreed orders can have multiple cases in them, in case ending in 055996, that's the sum of the total penalty was $1,000.
So that's the agreed order that was issued in, okay. And we had another one that was in November.
The administrative law judge was aware of them. It's dated November 16th, 2011. The first violation was that on April 2010, property tow in the absence of legally required signage. As I noted, that was a Class C violation. The other charges contained in that agreed order storage facility, and therefore we're not taking calculation of penalties.
Okay.
There was mention that the respondent refunded the fees before the investigation, or that the fees were refunded on this particular.
The refund was made prior to the involvement of the department. In the second case.
To the second, okay, to the second, okay.
Sure. Sure. You can proceed on. One thing I do want to remind you or make you aware of, we can only take information or evidence that was presented in the SOA hearing and nothing outside the record, just so you're
And that's what I'm going to present.
Go right
Mr.
ahead.
Chairman, members, commissioners, this is my first opportunity to be before the commission as an advocate. I did have the opportunity to, 15 years ago when my dad, I had to come to TDLR in a variance for 3/4 inch in the women's bathroom stall of being too short.
Was that presented in the hearing?
No, it was not. I'm just saying that this is only my second time with
Okay.
TDLR for that de minimis violation. I'm here with Mr. Venegas, who's my client representative, and we are here to ask the chair and the commissioners to substantially reduce, if not eliminate, the decision of the ALJ. And there are numerous reasons for this, and I would like to expand upon what Mr. Shirk said, because one of the statements he made was they were illegal, absence of legally required signs. The record reflects signage was there, and not only was additional words were clear that not only the vehicles statutorily required to be towed, abandoned vehicles and other types of vehicles, has more information for the consumer than. So when the statement is made in the absence of legally required signage, I think that stretches what the ALJ is. The other thing I would point out is we're talking de minimis issues here. When I walked outside to make a phone call a while ago, there is signage in this delivery zone immediately outside, where I, as a layperson, in looking at I don't think it complies with the statute with regard to marking of the delivery zone. Now, it's a de minimis issue.
I think we need to stick to the record of this case. This is Brad
I
Ball, General
understand.
Counsel.
What I'm saying, counsel.
Just stick to the information that was presented at the SOA hearing. I don't think that you were hearing that.
I'm making is it's de minimis, and what was not described by Mr. Shirk is were de minimis in that they types of vehicles than was required by the statute. So that's the first issue. The second issue is the manner in which at the Blue Star, there's a place in downtown San Antonio, the Blue Star Arts Complex. The vehicle that Commissioner Morgan asked about with regard to the refund, the person saw the sign, car was returned, and refund made by my client. It was a de minimis violation again. The bad thing about the Blue Star, it was not a restricted entrance area from the street. It was basically the street extended into the entire parking lot. Since this tow was made, the city of San Antonio has created curb cuts so that there is a specified entrance to the Blue Star Arts Complex and the Blue Star Apartments. The other issue on the second tow, again, in my opinion, it's a de minimis issue. The issue was parked on the roll gate of an exit only from an apartment community. The ironic thing is, the problem that the commission had with this, and TDLR had with this, is it is not posted on a pole.
Was that
next to-
picture presented at the hearing?
Yes, it was.
Okay.
Yes, it was. But the ironic thing about this picture, and at the roll gate, whether the gate is open or it is closed, the signage is visible to a person approaching the gate. Regulations by a company that, as found by the ALA judge, makes more than 1,000 tows a month, is a preferred contractor for the city of San Antonio. He refunded the first tow before there was any involvement by the TDLR. The second, again, is a de minimis issue because there was no parking permit on the vehicle. There was no parking permit on the second tow. We believe that the amount that was found by the ALA judge, by the administrative law judge, was far in excess of what the violation really consumer. These are high. As we're all aware, there's a lot of gotchas out there in the law, but if we're talking about notice to the public, notice to the consumers, the first tow, the person could see the sign and made the phone call to get her money back, got her car back, completely refunded. The second was because there was no parking permit on the vehicle. We would ask that the commission seriously consider reducing substantially judge's recommendation regarding, also take into consideration Class F. That's Class F. Thank you for speaking.
Any questions, Councilman? And I know that you said that more than what's required. Did the ALJ not changed?
I beg pardon?
The sign was changed?
There.
And so was that sign that was changed at that point in time contain additional information?
I don't know the answer to that question.
Well, your client
My
said
client
yes.
probably.
This took place, the sign changed, and it had more information.
No.
So
Referring to.
it is on, okay. Which is a PFD presented, but page 5. It talks about and it says, basically it says at the end, thus the ALJ assumes the sign was changed after the towing question. So ALJ is saying that the sign was changed after.
It took out the information.
It did not take out the information. It was.
There were one make it out now in the second sign. Is that correct?
No, it's not correct.
Could you explain that?
Do I have to sign?
Yeah, you do.
I think you sign it later, right?
Yeah, you can do it later,
You can do it
but
later.
you will have to fill one out.
Gentlemen,
Go ahead and state your name,
ladies,
please.
My name is Ricardo. I'm the owner of Atlas Towing.
Why don't you go and grab that mic to you?
My name is Ricardo Venegas. I'm the owner of Atlas Towing. The question the ALJ had that was in question was the exact verbiage of the sign. In our signs, we include as much as possible so that the general public is aware that if they are within to being towed. I'm going to read verbatim to what the sign says, and then I'm going to read what the ALJ was questioning. Our sign says, parking permit required. All guests must register vehicles during business hours, no exceptions. Permits must be visible prior to being hooked up to tow truck. Unauthorized, abandoned, improperly parked vehicles will be towed at owner or operator's expense. Well, the question was because it had abandoned, inoperable, and unauthorized backwards. It's all the same verbiage that the state requires. Unfortunately, the question was that because we didn't have unauthorized at owner or operator's expense, that's
She talked and she mentions in her footnote.
that is remained exactly the same in all the signs. The only thing that was changed was the unauthorized, in just one sentence, unauthorized vehicles will be towed at owner or operator's expense. As of prior,
it used to say unauthorized, abandoned, inoperable, improperly parked vehicles will be towed away at owner-operator's
All right.
expense.
All right.
And that's at the top of page 11, where the finding was made with regard to the additional language by the administrative law judge.
Okay. Any other questions?
Yeah. Is there?
Any questions
I'm
here? So
sorry.
if
Okay.
not, we can get them
Okay.
taken care of. Any other questions over here? Thank you.
Is there tickets in compliance with our requirements? Are they not in compliance? Their tow tickets, their invoices, and that they both have vehicle storage charges on there as well? Are they not in compliance, or are they in compliance?
It's the inclusion on a tow ticket of any charges or authorizations towing a vehicle to a vehicle storage for the safety. The mere fact those fees are all not mean that they have or does not mean that they have. We do not believe that that's a violation of the rule.
So
Now, and I think this needs to be clarified also, the back in 2011, there
That's
were
right.
Class
They have no
Cs.
prior Class F
Now,
violations.
between that time and now, they made a change, which meant that what was originally a Class C charge is now a Class F. And I think that needs to be clarified. As first Class F, that's correct. C, when it happened back then. So you are correct, but if we look at the charge itself, this is his third charge.
Well, that's correct. There was a prior incidence of towing in the absence. Right.
Okay.
On the larger presentation, however, the commission has always held that the similarly classified violations is not required. We've always looked chronologically. So if a respondent has a violation for years and then a violation of E or F,
Right.
even if they've only been A and Bs for the first two, we still treat that as a third violation. We do not
Understand.
telescope down to the lesser offense.
Sir, I'm sorry.
I have one last point
Statement, sure.
in response to Commissioner Morgan's question. The conclusion of law number 12 by the my client satisfied the department's rules, and that's in number 12.
Okay, thank you. Any other questions?
Regarding the signage, leads to addition of wards to a sign, does that make signs illegal?
The Texas Towing and Booting Act put certain words in quotation marks. It didn't say simply that a sign must advise a driver that their car is subject to tow. It said the sign must say, and then it actually has quotation marks. And that, even finding authority for the proposition, marks demand that certain language be on a sign there. It's my belief that a property owner can't simply put that ever want to get to on a sign that will be towed for that reason. There are the can be towed from an apartment complex. Reasons like ugly cars prohibited. So the legislature intentionally limited the amount of information that should be on a sign.
Any further questions?
Mr. Chair. Response to Commissioner Shaw, I'm sorry I'm taking up so much of the Commission's time, but I do want to point out on page 11 of the rule with Gail and concluded, he said, the include additional language as a separate clause or sentence. So at least the judge thought beyond what was in the statute.
God bless you.
But that was not, yeah.
Any further questions before we close testimony? Thank you, appreciate it. You can have a seat. And my understanding, Mr. Shirk, is that you are seeking a $4,000 administrative penalty per charge. $4,000 administrative penalty for all charges, and you were seeking a 1 year probation of his license. And the ALJ did not find reason to probate the
Did not
license.
find reason to suspend.
Suspend the license, okay. I just wanted to clarify that, but you're still seeking that.
Yes.
Okay, all right, thank you, appreciate it, have a seat. Commissioners, discussion, deliberation, or motion would be in order.
My comment is that I think that, the violations are, does a lot of tolls for the superintendent now. Some of the technical violations, difficult, and I think there's a process, there's a learning, there's a process that you get better as a result of when violations or things. I think that the violations are minimum, totals of $1,000. I would be supportive of the PFD as written or a lower fee. That's my comment.
Commissioner Shaw?
I'm going to agree with the right side of the table. I think you have to make it out with all the idiosyncrasies of downtown San Antonio. Those of you that have been there, know that it is, and parking is kind of rare. Signage, I have concerns about of what it occurred over here, so I'm more inclined to agree with maybe a reduction in fee, or maybe not even having a fee.
Commissioners?
I would suggest there were some violations, and maybe it's a learning process.
Well, and I can tell you that my input is that the department sought $4,000 per violation. I think we went down to $2,000, which to me is a pretty good per violation. I believe there does have to be some type of administrative penalty sought out. I'm not sure if, and I'm not sure if a probated sentence is warranted, considering, again, of course, the number of tows they do per month. I mean, it's 1,000 tows, that's a lot. When you begin to start taking a look that, over and,
That's right.
and they've had some charges before us, and I hope that, you always hope that you never see them back before you again, or never see it on the deferred order list. I'm not opposed to the 2,000. Of course, it does have a per incident.
I like the. I'll make a motion that we adopt the PFD. The fine be $1,000 per violation, or $2,000 max.
2,000 total, which would be changing conclusions of law 14.
And are we getting rid of, there was an,
It's not
No,
in
the AOJ did not have a probated sentence on there.
That's right. That's my motion.
We have a motion.
Do there need to be modifications to the PFD?
Chairman, do we need a second before we start discussion?
Yes, we do.
Okay, sorry.
I'll
We have a
second that motion.
Seconded by Commissioner Butler. Okay.
Discussion.
Commissioner Morgan had some
I
questions.
said, do there need to be some modifications?
And the findings of fact.
Yeah.
Yeah, it depends what the conclusions of all 14, because basically we're. Just we can check off.
Mr. Chairman, could I just amend for cases involving LJ agreed to in response to the department's exceptions having to do with the refunding, that it was one of the complainants that was refunded, not both of them. So that was,
So that was just the, but that was the modified POD that we
yes, the
received.
judge agreed to that.
I'm sorry, I assumed we were talking about the modified POD. Is that
Yeah.
correct?
Yeah, we are.
Okay. Are you clear with that? Commissioner Butler?
Yes.
Okay. Commissioner Shaw.
As you look at the amended PFD, had the motion maker look at, because there was one we paid, they charge $1,000 fee for the, and not the other one.
And whether there was a refund or not, I think there were some, I think the PFD, fine. Well, he modified it by 3 or but I think 2 slightly. So that's why.
The motion stands.
That's why.
Yes, sir, Commissioner.
Word of note here, and then you can call the question. A couple of things. First, if you do 1,000 tows, and what that counts to about 12,000 tows a year, you're bound to make a mistake here or there.
Oh, yeah.
And there's going to be, I hate to say, sometime soon in my
I hope not.
tenure here, but 12,000 tows is going to create some mistakes in there. So for that reason, I'll be voting against this motion, because I think it would be right to just assess a one fee.
To adopt the modified PFD with conclusion of law, I believe it's 14, is that correct? Which is essentially two
Before you ask the question, could I ask Commissioner Shaw a question? What your approach is, they did in the one case, you would be charging them of instance where they did not refund.
That is
I think that's reasonable.
rectified by the applicant here. The right thing to do is to assess a
Does everybody have the same understanding that this sign was on?
You seconded.
Yeah, I know. I just
Okay.
wanted to understand where Rob
Yes,
was coming from.
Okay.
it was a movable building, yes. That's correct. So my parents that comes to exit game. Any further discussion? All in favor signify by saying aye. Aye. Those opposed, no. If you don't mind, let's take a roll call.
Aye.
Aye.
Motion carries 5-2. So adopted with a penalty of $2,000. So we thank you